So Joe Exotic, the guy that pretty much everybody in the world now knows from the Netflix original series Tiger King, Murder, Mayhem, and Madness, has filed a pro se lawsuit against multiple defendants, and I've got to say, this pro se lawsuit illustrates the fundamental risks of pro se lawsuits. Viva Frei, Montreal litigator turned YouTuber. We are now in week 5 of the global lockdown, and I'm thinking that I am actually going to let my kids cut my hair today. If you are one of the few people on Earth who has not yet heard of this Netflix original series, Tiger King, Murder, Mayhem, and Madness, you probably need to get out of your house a little more if you can without getting arrested. Jokes aside, for anybody who doesn't necessarily know exactly what's going on, Joe Exotic is a guy who appears on this Netflix series called Tiger King. His real name is Joseph Moldano Passage. He is currently incarcerated, serving a 22-year sentence for convictions of the Endangered Species Act violations and murder for hire. He was a big cat owner, had a private zoo in the United States with over 200 big cats, and the Netflix documentary documents the true story of these private zoos, their battle with animal protection rights groups, etc., etc. It is a fascinating documentary. If you haven't seen it, I don't want to spoil it for you. If you have seen it, no need to go over it again. And while I don't want to spoil anything for anyone who has not yet watched the series, I am going to go through Joe Exotic's pro se lawsuit, which he has filed from prison. And in so doing, we are necessarily going to go over certain things that are in the documentary. So spoiler alert, if you don't want to know anything about the documentary, go watch it first before watching this video. But watch this video anyhow because it's going to be fascinating. First things first, what is a pro se lawsuit or a pro se litigant? It is a self-represented litigant. Pro se is Latin for in one's own behalf. Now, in previous vlogs, I have talked about the risks and perils of representing oneself in the court of law. I, in fact, did an entire vlog on the subject, why it is not necessarily the best idea to represent yourself to the extent that you have access to a lawyer. If you haven't seen that vlog yet, I'm going to link it right here. Give it a watch. It's kind of insightful, if I do say so myself. Some litigants are, in fact, able to effectively represent themselves. I have, in fact, been in cases where I have seen people representing themselves probably better than most lawyers would have represented them. But that does not change the fact that there are certain fundamental risks, perils, and problems in representing oneself, and the Joe Exotic pro se lawsuit illustrates those risks and perils. With that said, let's just jump right into reading this lawsuit, and bear in mind, forewarning, I'm not going to go through the entire lawsuit in its intricacies because you're going to see why, but let's just get into it. So here we are looking at the civil cover sheet of Joe Moldano Passage's civil complaint. Plaintiff, we see Joe Moldano pro se. Basis of jurisdiction, we see that the U.S. government defendant is checked off. Nature of the suit, place an X in one box only. And notwithstanding those instructions, here we see the nature of the suit. Real property, all other real property, torts, other fraud, other personal property damage, civil rights, other civil rights, prisoner petitions, civil rights, civil detainee conditions of confinement, other statutes, False Claims Act, commerce, agricultural acts. Preliminary comment, I am a Quebec and Canadian attorney, so I have no knowledge of the proper law and procedure in whatever jurisdiction this pro se lawsuit is filed in. Nothing in this video or any of my other videos constitutes legal advice. If you have any legal questions, consult an attorney in your proper jurisdiction who can answer you properly. My first observation is that in this form for the nature of the suit, it says check one box only, and Joe Exotic checks nearly a dozen boxes. Although I have no specific expertise in the law or procedure in this particular jurisdiction, I can imagine why it is that they are only supposed to check off one box. Different types of claims might be subjected to different types of procedures, different types of laws, different types of tribunals. And so a claim that is based on civil damages resulting from property damage might be heard by a different tribunal than a claim that is challenging the constitutionality of certain legislation. And so it may already be a material procedural abnormality that 9 boxes of the nature of the claim are checked off where it says to check off only one box. This is not to assess the legitimacy or the ill-foundedness of any of the 9 claims. It might just be that for each of the 9 claims, he might have to file a separate statement of claim. Again, not knowing any better, but something in me questions whether or not you can join a claim under the Agricultural Act for a claim in civil damages for damages to property. Those are my initial reflexes in reading this cover sheet, and if I'm onto something and somebody knows better, please let me know in the comment section below. And then we move on to the procedure of the United States District Court complaint for violation of civil rights. Now, I'm going to skip over certain parts of this because there is identifying information of some of the defendants, and that is totally irrelevant for the purposes of this vlog. I want to jump to section 3 in particular because it's going to be relevant for the rest of this vlog. Prisoner status. Indicate whether you are a prisoner or a confined person as follows. Convicted and sentenced federal prisoner. Why is the fact that Joe Exotic is a convicted and sentenced federal prisoner? Well, we're going to see when we read through his civil statement of claim that a lot of the claims that he raises in that lawsuit, they're going to be without object to the extent that he was found guilty in a criminal court of law for those allegations. Statement of claim, state as briefly as possible the facts of your case, And then we see at the bottom here, see attached number 3. Let's go to attached number 3. Attachment number 3, U.S. Department of Interior is requiring me to hold a Class C exhibitor's license and be inspected by the USDA APHIS inspectors, follow the Federal Animal Welfare Act. When I do what I am told, the departments of other agencies call the U.S. Fish and Wildlife, had me arrested, charged and convicted me for doing what the USDA APHIS instructed me to do. U.S. Fish and Wildlife placed generic animal tiger on the endangered species list for the reason to stop the breeding of generic tigers, not to protect them. Also to allow them to file charges to put me in jail and out of business, therefore stealing my property and promoting an animal rights agenda. Matthew M. Bryant selecting enforcing the Endangered Species Act only on me. Assistant U.S. Attorney Amanda L. Green malicious prosecution to further an animal rights agenda. Jeffrey L. Lowe files false statements to the federal agents. Daniel Ash conflict of interest and serving a personal agenda by putting generic tigers on the ESA and being president and CEO of the AZA who hates private zoos and breeders. James Garrettson, government informant, was offered $100,000 to set me up while he was stealing people's IDs and credit cards, lying under oath. Alan Glover was an employee of Mr. Lowe and followed Mr. Lowe's every order. Right now we are seeing one of the problems of the pro se litigant or the pro se lawsuit. It's something I've said in previous vlogs, but representing yourself is sort of like a doctor trying to operate on themselves. Even if a doctor has the requisite knowledge and skill to perform the surgery on somebody else, when a doctor performs a surgery on themselves, they don't have the same perspective that they have when performing it on somebody else. Not only do they not have the proper perspective, but following the analogy, anybody operating on themselves would be overcome with the pain of operating on themselves. Pain causes poor decisions both physically and emotionally, and a pro se litigant is in pain, they are under stress, and they are not necessarily able, even if they have the requisite knowledge, to make proper decisions for themselves. And here we see Joe Exotic throwing everything under the sun into one complaint to the point where it becomes very difficult to digest. Injuries. If you sustained injuries related to the events alleged above, describe your injuries and state what medical treatment, if any, you required and did or did not receive. I have been sexually assaulted, scared from being tied in a chair, was given band-aids. And here again, it seems that we might have mixing up of two claims that have totally different bases. The injuries that Joe Exotic alleges to have sustained while in prison, which incidentally sounds like absolute hell, versus the injuries that he sustained as a result of the basis of a lawsuit outside of prison that landed him in prison. I am not making any claims on the validity of any of these lawsuits, but when they are jumbled together in one and the same statement of claim, it becomes very difficult, if not impossible, to parse through. Relief. State briefly what you want the court to do for you. Make no legal arguments. Do not cite cases or statutes. If requesting money damages, include the amounts of any actual damages and or punitive damages claimed for the acts alleged. Explain the basis for these claims. I want the law to be enforced fair and equal. I am the only person criminally charged while the government lets a private non-profit group civilly sue everyone else and want repaid for my personal property and 18 years of research lost due to this. They are misreading the law just to further an agenda. $73,840,000. From the basis of the statement of claim, it basically sounds like Joe Exotic is using the civil courts as an appeal to his criminal conviction. And this will become more apparent when reading through the civil claim, but just to skip a little further down in this particular procedure, which reads as follows. What steps, if any, did you take to appeal that decision? Is the grievance process completed? If not, explain why not. Appeal is currently ongoing. So it would seem that Joe Exotic is appealing his criminal conviction. That being said, for the time being, he has filed a civil lawsuit claiming damages for things for which he has in fact been found criminally guilty. One does not have to be a lawyer to see the potential problem in that type of process. With that procedural framing in mind, let's now go read the pro se lawsuit itself. In the United States District Court for the Western District of Oklahoma, Joseph Allen Moldano Passage, plaintiff versus defendants. United States Department of Interior, United States Fish and Wildlife Services, former Director Dan Ash, Federal Wildlife Agent Matthew Bryant, Assistant U.S. Attorney Amanda Green, confidential informant James Brandon Garrettson, Jeffrey Lee Lowe. Pro se civil rights complaint. Joseph Maldonado Passage, the plaintiff, is filing this pro se against defendants for the following counts: misleading a grand jury, perjury, conspiracy to commit perjury, false arrest, false imprisonment, malicious prosecution, loss of personal property, pain and suffering, mental anguish, the death of Shirley Schreibvogel, discrimination, selective enforcement, misrepresentation of the Endangered Species Act, violating federal defendant's oath of office. Like I said before, these headers of damages mix claims that might be subject to very different procedural requirements. They might be subject to the specific jurisdiction of different tribunals. And one thing that is apparently obvious is that some of the headers of damages include things for which Joe Exotic was found criminally guilty. In the ordinary run of things, you can't sue civilly for damages for acts for which you were found criminally guilty. And as we read through the introductory paragraph of the backstory, you're probably going to more fully appreciate my doctor operating on themselves analogy. Backstory. In 1998, the plaintiff, along with his parents, built a rescue zoo in Wynwood, Oklahoma. The zoo opened in 1999, providing a home to all different species of exotic animals. The zoo grew into one of the largest private zoos in the United States, housing over 200 200 tigers and nearly 400 other exotic animals at one time over the next 18 years. From about 2006 on, the plaintiff was stalked and harassed by an animal rights advocate who owns Big Cat Rescue in Tampa, Florida. The CEO of Big Cat Rescue, Carol Baskin, bragged on her business website that she paid an employee of Big Cat Rescue, Sue Bass, $35,000 to follow the plaintiff's every move. Carol Baskin then built a website called 911animalabuse.com, listing the plaintiff, in her own opinion, an animal abuser, for using tiger cubs in public interaction events such as magic shows and fairs. At one point, she placed the plaintiff's name on the internet as her most wanted abuser. And it goes on for another 2 pages. Joe Exotic goes on to detail the rivalry between him and Big Cat Rescue that started with him posting online a picture of Big Cat Rescue, Carol Baskin, holding dead rabbits that she was about to feed to a tiger or something. It then goes on to summarily allege certain lawsuits filed by Big Cat Rescue against Joe Exotic and his zoo. The plaintiff sent this photo to rabbit rescue organizations all over the country. To stop plaintiff from distributing the photo, Carol Baskin paid to copyright it and filed a lawsuit against the plaintiff for copyright infringement. After a long court battle, the plaintiff let her obtain a judgment against him in Florida. The CEO of Big Cat Rescue moved the judgment to Oklahoma, where the plaintiff filed bankruptcy, and BCR, Big Cat Rescue, sued the bankruptcy court and paid $33,000 for the plaintiff's 1/5 of a family trust left by the plaintiff's grandfather. BCR continued to file lawsuits even against the plaintiff's mother, Shirley Schreibvogel, in an attempt to not only bankrupt the zoo, but also the plaintiff's family with legal fees in federal court. BCR would continually dismiss the suits right before they were to go to a jury trial, then pick them back up a month after the trial date expired. This is incomprehensible even if there is a legitimate claim somewhere in there. The plaintiff is using certain legal terminology in an inaccurate manner that just doesn't make sense. A plaintiff does not dismiss a lawsuit before a trial by jury only to pick it up back afterwards. It doesn't even make any sense in the legal sense. And this is the problem of a doctor operating on themselves or a litigant representing themselves. They may not have the technical knowledge to draft the allegations properly, or they may be so emotionally involved in the situations they're just incapable of describing the situation properly. Joe Exotic then goes on to allege that animal rights activists are effectively politicizing the Endangered Species Act by having generic tigers added to the list only so that they can target private zoos. Ultimately, it might in fact be an interesting argument to challenge the constitutionality of the law, but typically one does not do that by way of a civil lawsuit for damages. The ESA, the Endangered Species Act, is being used by animal rights groups and the federal government to make generic, privately owned tigers extinct, which is completely against the purpose Congress made the ESA, which was to save a species, not make it extinct. Then we get into the substance of the claim, which starts with a 30-plus sentence paragraph. If you have been watching my vlogs for a while, you know that I frequently quote Abraham Lincoln, who wisely once said, "Don't allege that which you need not allege, lest you be required to prove that which you cannot prove." Bearing in mind, when you read a lawsuit, typically the plaintiff is going to have to make evidence of each and every allegation they include in their proceedings. The more allegations you make, the more you're going to have to prove, and the flip side, if you don't prove those allegations, the more allegations you have not proven. And typically you are supposed to allege one fact per paragraph so that someone reading that paragraph knows specifically what the allegation is and what evidence needs to be made to support that allegation. So coming into the claim off the bat with a 30-plus line allegation that contains all sorts of allegations, from starting a private zoo to the unconstitutionality of the Endangered Species Act to mail theft, ID theft, murder for hire, nobody is going to be able to make sense of that allegation. This is one of the most common problems with the pro se litigant. They want to tell their story, but they don't know how to break it down to tell it properly to a judge. And so all too often it comes out as a stream of consciousness that doesn't categorize facts and allegations in any discernible manner. And this is exactly how Joe Exotic's lawsuit reads. Around September 7, 2018, a federal grand jury was misled with the perjury testimony of Alan Glover in order to obtain an indictment against the plaintiff for 2 counts of murder for hire. The plaintiff was then arrested in Gulf Breeze, Florida, where he had made his home after leaving the zoo. The plaintiff was transported to Grady County Jail in Oklahoma City, where he remains without bond. During the course of this malicious prosecution, the plaintiff would not take a plea to the murder for hire charges, so the government superseded the indictment with 20 wildlife charges to make the plaintiff pay the price for asking for a trial. It's something we see frequently in criminal law, and it's actually something we saw in the Lori Loughlin-Felicity Huffman scandal. You may or may not recall, but Felicity Huffman and Lori Loughlin were brought up on charges of mail fraud and honest services mail fraud. Felicity Huffman pleaded guilty to her initial charges and served 14 days in jail, but Lori Loughlin did not plead guilty to the charges. And what ended up happening to Lori Loughlin? Well, they came in with a superseded indictment which added charges to the initial charges against Lori Loughlin. I've done a couple of videos on that subject. I'll link one of them right here if you haven't seen it. Give it a watch. But in those videos, I did comment on how this practice can be seen to be somewhat abusive, as in plead guilty to the initial charges, or we are going to supersede the initial indictment with an indictment that has even more charges, so you're going to face even more time in jail for not pleading guilty to the original charges. A superseded indictment just means an indictment that takes the place or overrides the initial indictment, and it typically includes more charges, not less. And this is exactly what Joe Exotic is alleging was done to him. Because he didn't plead guilty to the initial charges, they came in with a superseded indictment that added all sorts of other charges for animal cruelty to the initial indictment so that he faced even more time in jail. That being said, although it raises interesting questions, it seems like it might serve better as the basis for an appeal of the criminal conviction and not the basis of a lawsuit civilly for acts for which he was found criminally guilty. That being said, you can't necessarily blame Joe Exotic because he is representing himself in this civil suit. I just hope he has proper representation for the criminal appeal. He doesn't necessarily know the proper rules or procedure for a civil lawsuit, and he might just be applying mutatis mutandis what he saw in his criminal lawsuit. The bottom line, he's making allegations claiming damages for perjury and a grand jury being misled, but he was found guilty in a criminal court of law on those charges, so his chances of succeeding on a civil claim, unless the criminal claim is overturned, are nil. These are allegations that ought to have been raised in his criminal defense in the criminal trial, and I hope they were. But these are totally improper and baseless allegations to be claiming civil damages when you are in fact found guilty on those charges in a criminal court. Argument. The plaintiff argues that the United States Department of Interior and the Federal Fish and Wildlife, along with the former director of the Federal Fish and Wildlife, placed the generic tiger on the ESA not to protect it, but for the sole purpose of targeting certain individuals and businesses that breed and use generic tigers in commercial businesses. Straight off the FWS, Federal Wildlife Service website, under the ESA Section 4 General, it states, by removing the exemption, the service can reinforce the value of conservation breeding of individual tiger subspecies and discourage the breeding of intersubspecies crossed or generic tigers. This statement clearly shows the government is not trying to protect the generic tiger, but to end their breeding and cause the generic tiger to not exist. He may have a point, he may have an argument, but I am not entirely convinced that a civil lawsuit is the proper forum to make these arguments. The plaintiff holds the United States Department of Interior responsible for the false arrest and false imprisonment of the plaintiff due to the fact that this department oversees both the USDA APHIS and the FWS under its watchful eye, and the USDA APHIS division is who licensed, inspected, and instructed the plaintiff what and when to do things such as construction, safety, health, veterinarian care, enrichment and diet protocol, along with the staff training, and to keep in line with the Animal Welfare Act. Claiming damages for false arrest and false imprisonment on charges for which you were found criminally guilty, I don't think it's going to work. And it goes on. I'm going to post screenshots of the lawsuit so you can pause and read it at your leisure, because we can only get so much out of it from reading it. And ultimately, I'm not sure how many people are interested in just watching me read through a lawsuit. But let's just skip to the last paragraphs of the lawsuit. The plaintiff contends that this is the worst kind of gross negligence on the part of the government's side of tearing down the very justice system that this country is built on by allowing perjury to gain false convictions, selective enforcement of the law, discrimination, and blatant violation of the oath to uphold the law equally and fair. Relief requested. Plaintiff is seeking the loss of personal property, 18 years of research and care of 200 generic tigers and crossbreeds for 365 days a year for 18 years at a boarding rate of $60 a day per animal for a total of $78,840,000, and an additional $15 million for false arrest, false imprisonment, discrimination, malicious prosecution, selective enforcement, misinterpreting the law, and the death of Shirley Schreibvogel. It's not infrequent for people to use lawsuits to vent and to tell their story to the world, but typically when they are represented, they have lawyers who sort of gauge the manner in which that is done. And that is typically one of the biggest problems when it comes to pro se litigants. They too want to tell their story, but they don't have a lawyer to tell them how to do it properly. And so all too often the lawsuit effectively turns into a stream of consciousness where the pro se litigant wants to tell their story literally from beginning to end and be righted for every wrong that they feel they have suffered. And it turns into a lawsuit that consists of allegations that are difficult, if not virtually impossible, to make legal sense out of. There may be legitimate civil claims somewhere in there. There may be legitimate claims against the drafting of certain legislation somewhere in there. There may be legitimate defenses or grounds for appeal on the criminal convictions somewhere in there, but it's impossible to parse it out the way it is drafted. I hope you got something out of this breakdown, and if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below. It feeds the algorithm. If you know someone you think would appreciate my channel, share my channel with them, and if you want to support the channel, all the support links are in the pinned comment, and now you know your vlog. Peace out.